All right, good morning, everyone. It's now day 3 of this fantastic event. I hope everyone's having a very productive and enjoyable week thus far. And it's still early for some of us yet. It's still early for me. And we're going to start off with an exciting topic called government enforcement defense, coordination and cryptocurrency investigations. And we have a fantastic panel of speakers today. We'll do an introduction shortly. In terms of this topic, we should be talking about, we will be talking about some of the key events that's developing in the world of cryptocurrency. And as you all know, after years of exponential growth in the market, we are starting to see some significant events that's developing, especially some catastrophic falls and fails of the key players and industry leaders in the last couple of years. And because of that, we're seeing various government agencies notching up their enforcement activities as well as regulatory scrutiny. And that's leading to a lot of joint parallel investigations by key jurisdictions, namely South Korea, even the United States. And I think it's the right time to discuss what's going on in the world of cryptocurrency investigations and enforcement, and also how those key jurisdictions are working together in their enforcement actions. So we're going to talk about the following agenda: international nature of crypto enforcement, Korean regulatory enforcement framework, U.S. regulatory enforcement framework, and cooperation between Korea and the U.S., and U.S. enforcement developments. We have limited time, but subject to availability in terms of time, we'll open the floor for questions. So if you have any questions, please jot them down, and we'll try to cover them at the end of the session. All right, so before we delve into the presentation, I would like to introduce our panel members. We begin with David Olivenstein from Pillsbury. David advises clients on complex investigations, regulatory and criminal enforcement, securities law, and securities litigation. And prior to joining Pillsbury, David was with the SEC's Division of Enforcement, where he served as senior counsel in the market abuse unit, in all units responsible for investigating cyber and digital asset related misconduct. Next, we have Emily Clark from Kim & Chan. She has an extensive practice in the areas of corporate investigations and white-collar defense and corruption and corporate compliance. Emily has assisted a broad range of multinational and domestic companies on criminal defense and corporate investigations related to various allegations, including internal investigations conducted in connection with investigation by U.S. authorities. Next, we have Bill Martin from O'Melveny. Bill has a wealth of experience in government and private practice that enabled them to guide financial services companies, blockchain, fintech. Prior to O'Melveny, Bill was a senior counsel in the U.S. Securities and Exchange Commission, and during his tenure with the SEC, Bill worked closely with, among others, the Justice Department, FBI, IRS, and FINRA. I'm your moderator, Daniel Lee, from the law firm of Korea & Kim, where I represent multinational companies and high net worth individuals in civil and criminal procedures. Proceedings including whistleblower investigations, bid rating, export and import controls, international sanctions, extradition and inter-corporate matters. And prior to joining Korea & Kim, I was a federal prosecutor in the U.S. in the Department of Justice, and also worked for the U.S. Department of Defense. So with that, I'll hand it over to Bill to talk about international nature of crypto enforcement.
So to start off, we wanted to give a high-level overview of some information regarding cryptocurrency. The global crypto market, as measured by market cap, is estimated to be in the trillions of dollars. And says there's no indication that it's cooling. You may say, well, but I thought the prices of cryptocurrency have dropped over the last couple of years. That's fair, but for us who represent clients working in this space, I can tell you that there are just so many projects that are continuing to develop new applications for these assets. So in that respect, the industry itself just continues to grow, to develop, to innovate. It's estimated that there's approximately 420 million people who hold cryptocurrency around the world. That number is also going up as the asset becomes more ubiquitous. And increasingly, it's not just individual asset holders, retail asset holders, but institutions are getting more and more interested in holding cryptocurrency, different kinds of cryptocurrency, and using it for different purposes. Against this backdrop, regulatory authorities are trying their best to keep pace with all of these developments. One of the challenges is that the technology itself just continues to evolve, and it is spreading to new use cases, new applications. And the question is whether the existing regulatory framework, whether it's in the United States or in Korea or other countries, is able to keep pace with those changes. Next slide. So here we have various kinds of digital assets. This is not even an exhaustive list. There are many other labels for different kinds of digital assets, but these are some of the more common ones. So I'll just run through these. A utility token refers to a digital asset or cryptocurrency that is intended to be used for some kind of consumptive purpose. And the shorthand for this is that this kind of token would have a use case. If they do have a use case, that weighs strongly against the likelihood that it would be considered security, at least in the United States. Payment token refers to a digital asset that is intended to be used generally for making payments, so not just within one ecosystem or on one platform, but more broadly than that. An exchange token refers to a digital asset that was created and intended to be used on a trading platform. So we can talk about some examples of that later on, but one that we'll talk about is Binance's exchange token is called BUSD. And so that was created in order to facilitate trading on that platform. A governance token refers to one that confers certain voting rights upon the holder of that token. And those voting rights can be used for different things, such as proposed changes to the network or the platform on which that asset resides. A non-fungible token is one that, unlike most other cryptocurrency, is actually not interchangeable with other tokens. It is intended to be totally unique. And what it's really designed to do is to prove ownership of a unique digital or physical asset. And so that can be used for managing digital assets, digital property, but it can also be used for physical property as well. The next one is DeFi tokens. This refers to tokens that are created in connection with a decentralized finance platform. One example of this would be one called SETH, which stands for State Ether. And that's the platform Lido. So what happens is you would basically send your Ether to Lido, and in exchange, you get a State ETH token that you can then trade and sell and do what you want with it. Stable coins, these are digital assets that are intended to be pegged to another asset. Typically, this would be a fiat currency, like the US dollar. The largest stablecoin by market cap is Tether, which goes by the ticker symbol USDT. Asset-backed tokens are digital claims on a physical asset, and they are backed by that asset. So one example would be a digital asset that is backed by gold. Another possibility would be digital assets that are actually intended to fractionalize ownership of physical assets, such as real estate. So these are some of the possibilities for asset-backed tokens. The final one is called security tokens. These are tokens that are intended to be function very much like securities. These are not allowed in the United States so far. The SEC would need to approve the use of those tokens. And with each of these labels here, some assets can take on more than one label. I had mentioned BUSD before, so that is an exchange token. It is also intended to be a stable coin. That's Binance's stable coin. And when regulators in different jurisdictions are thinking about how they want to approach digital assets, different regulators may have concerns about different kinds of digital assets. The SEC and other securities regulators around the world will certainly be focused on things like security tokens, but stable coins might not make as much sense for securities regulators to focus on. That may seem more appropriate for banking regulators. So it really depends. Next slide. So why is cryptocurrency an international enforcement focus? For one thing, cryptocurrency just is international. It moves through the internet from one wallet to another wallet, doesn't really recognize physical boundaries. And across different jurisdictions, regulators and enforcement authorities are going to perceive cryptocurrency differently. In some jurisdictions, they may look at cryptocurrency as offering many opportunities, but also, raising certain concerns and posing certain risks. So, it's an emerging market based on an evolving technology. As I mentioned before, this is a new technology, it continues to evolve. And with all of these applications that are being developed, regulators are going to struggle to keep up with all of these different changes and how those changes in the technology may implicate different laws, different regulations for their own jurisdiction. In addition, there will be some failures. And when ventures do fail, a lot of regulators would have the concern that those failures may have broader economic impacts than anyone anticipated. As Dan mentioned, in the last year and a half, we have seen some high-profile failures. And whenever one of these episodes occurs, the question is, well, how broad is the impact going to be? Who's affected? How much exposure do they have? And as we've learned, you often don't realize the full extent of those impacts for some time. Another reason is that there are different perceptions regarding crypto investors and crypto purchasers. Enforcement authorities may view some purchasers as essentially buying this for illegal purposes. Others may view a lot of retail purchasers as perhaps essentially speculating or gambling, and therefore there may be more of a perceived need to protect those purchasers essentially from themselves. There's also going to be different perceptions concerning bad actors in this space. And, here we have just a few of the more high-profile failures and bad actors in the last couple of years. When these things happen, they do not build confidence among regulators in cryptocurrency, and sometimes they can actually support a lot of skepticism toward the asset class. And finally, certain regulators may think that the rules of the road that they have in their existing regulatory framework are already very clear. And there really is no need for new laws, new regulations. The SEC in the United States is a good example of this. But other jurisdictions realize the need for new laws, new regulations, perhaps a new approach to this new asset class. That, I think I hand it to David.
That's right. Good morning, everyone, and thank you for being here with us today. So Bill just spoke about why crypto is such a significant enforcement focus. And this slide confirms that top U.S. officials responsible for crypto-related enforcement share the views that Bill articulated. This is a quote from the SEC's enforcement director, in which he expresses the view that digital assets represent a particular threat to certain types of investors, particularly to non-white and lower income investors who are perceived to be more vulnerable or perhaps skeptical of traditional financial systems, and so more likely to purchase digital assets based on that logic. And so this is really meant to underscore the view that part of what is driving cryptocurrency regulation, at least in the United States, is a desire to protect perceived vulnerable populations who are getting into this space. But another thing that I find interesting about this particular quote from the SEC's enforcement director is that he's acknowledging that the issues that are presented by crypto regulations are novel. And that's sort of an odd and striking statement to people who practice in this space, because as most of us know, the SEC, including its senior staff and senior leadership, have routinely taken the position that, no, this is not novel, there's nothing to see here, the rules of the road that are applicable to crypto are clear and well settled. And we're going to discuss this in a little more detail later in the presentation, because we're going to spend some time talking about how digital assets are classified in the US, whether as securities or commodities or something else altogether. And usually the SEC just takes the position, as I said, that there's nothing novel, there's nothing to see here because the rules of the road are settled. Crypto is clearly a security in most cases. Obviously, the SEC's position in that respect comes from a little bit of self-interest because they want their regulatory regime to apply as opposed to other potential regulatory regimes. We can move to the next slide. And so what we're here to talk about today are issues that arise in connection with cross-border cryptocurrency matters. And cross-border investigations generally, they're always going to be complex, in part for procedural reasons. You've got things like foreign data privacy laws, privilege considerations, inconsistencies in how various jurisdictions apply privilege considerations, and we'll get into that a little bit later in the presentation. But for now, what I want to point out is that there's an additional layer of complexity that applies to cross-border cryptocurrency investigations, because this is a context where for most jurisdictions, particularly the United States, they're still developing the various regulatory regimes that will apply to digital assets, including in relation to very, very fundamental aspects of digital assets, like how digital assets are classified, tax issues, insolvency considerations, and so forth. So while dealing with the various intricacies that are inherent in cross-border international investigations generally, an additional layer here is that the substantive body of law that might be applicable to the regulations in various jurisdictions may very well be unsettled. And just to make this a little more concrete. If you have a significant cross-border crypto-related investigation pertaining to fraud, hypothetically speaking, of course, in which the conduct reaches and impacts many countries, you could have a situation where Interpol is involved, Europol, as well as criminal and regulatory authorities from various countries. In the US and in many other jurisdictions, financial regulation, in addition to taking place at the national level, also occurs at the state and local levels. So if you have a major crypto fraud, you might face different opinions, not only among different countries, among different jurisdictions, regarding the basic question of what is crypto and how it should be classified, but also several different opinions among various authorities within each jurisdiction, between regulators and various local jurisdictions. So all of that really has to be considered when helping a company or a client navigate these cross-border crypto investigations.
All right, thanks, David. Well, now we've looked at the basic international enforcement landscape. We're going to discuss two key jurisdictions in comparison and how they cooperate in cross-border investigations. And to begin with, Korea. Over to you.
Yeah, sure. So regulation of cryptocurrency in Korea is still fairly in the early stages, but it's quite active. For example, new bills are being introduced, and one example of the bill that's pending in the National Assembly is a bill that would require entities issuing or possessing virtual assets to make clear public disclosures. And in such connection, the financial regulators have been working on amending the related accounting standards and requiring disclosure and witness. But what the public is more familiar with are the high-profile investigations that Bill and David talked about, and that's really what gets the public's interest. And when there's allegation of wrongdoing, like fraud, hypothetically, that we talked about, or other issues like insider trading, tax evasion, whatnot, the cases are quite aggressively investigated by the prosecutors in Korea, and often with the involvement of other authorities like the financial regulators, and under the supervision of the Ministry of Justice. To give an example, the Korean prosecutors conducted an extensive investigation following a catastrophic fall of cryptocurrency that was offered in Korea and also globally, and made indictments, and the trial is in progress. And to give another example, it was revealed in spring of this year that one of the Korean lawmakers who had rather a clean image actually had taken advantage of an unfair opportunity to invest in crypto and made huge gains, which in violation of conflict of interest rules, and a special investigation team was formed to review the crypto trades by lawmakers, and that's going on. So you can see that the investigations are quite active in Korea, and some of them are cross-border investigations when obviously the crypto is offered everywhere in the world.
Right,
Thanks.
thank you. Well, so we will delve into the U.S. regulatory enforcement framework.
Sure. Go to the next slide. In the United States, there are several different agencies that are focused on cryptocurrency to one degree or another. When I think of the United States and how the U.S. has been approaching this compared to other countries, and one important thing to keep in mind is that other countries may have a financial regulator that really addresses a whole series of areas that cover a lot of finance. That's not how the U.S. really works. We have different regulators for different activities. It's very fragmented. And that's just at the national level, the federal level. You also have 50 states. They all have their own financial regulators, and state attorneys general. So it's very complicated. And one thing that we've all had to deal with from time to time is an investigation by one agency that is ongoing at the same time as another. And we're responding to different agencies. We're trying to get the best outcome for our client, but it can be very challenging. So, some of the key players here, starting off with the Department of Justice. When it comes to cryptocurrency, the DOJ investigations, and more importantly, the cases that they bring in court, tend to be the criminal cases. When they are investigating, it's not unusual for them to be working very closely with some of the other agencies here that I'll talk about in a minute. So there may be an investigation going on where Department of Justice is sending out its document requests and it's interviewing people, but at the same time, they're working alongside the SEC or the CFTC, basically investigating the same conduct. Right now, the Department of Justice has a rather high-profile trial going on in New York against the founder of the now defunct trading platform FTX and its founder and former CEO Sam Bankman-Fried. David will talk some about that later on. The SEC, unlike DOJ, cannot pursue criminal charges. It can only pursue civil charges against individuals and entities. The SEC is the securities regulator, and it is probably the most aggressive among these agencies. As David alluded to earlier, the SEC takes a very broad view of its jurisdiction, and it pursues those cases quite aggressively. It has recently increased the number of attorneys and investigators focused on cryptocurrency matters. And we'll talk some more later on about the extent of the SEC's authority and some of their high-profile enforcement actions. The next agency here is the Commodity Futures Trading Commission, the CFTC. The CFTC regulates futures contracts, options contracts, other derivatives, and one of the things they can investigate are failures to register an entity as essentially like a commodities broker or commodities exchange. But they will also be investigating fraud and market manipulation. The next are banking authorities. Here, this usually means the Federal Reserve, the Office of Controller of the Currency, and the FDIC, the Federal Deposit Insurance Corporation. Each of these agencies have their own mandates, and they may have their own concerns, but one, just in recent years, that the banking regulators have been focused on are banks doing business with companies in the cryptocurrency industry. They haven't prohibited them from doing business with them or having them as customers, but they've raised a number of concerns. Treasury, I think of when it comes to tax issues because the IRS is part of Treasury. And when it comes to sanctions, the Office of Foreign Asset Control is sort of the key agency there. Main concern being whether crypto is being sent to sanctioned individuals, sanctioned organizations, or just sanctioned jurisdictions. And as I mentioned, there's also state authorities. Oftentimes they're looking at many of the same things. They have their own statutes, they have their own authority, but it will often overlap with what federal authorities are looking at, except they're focused on just their own state. Go to the next slide. So, one question that the SEC at least needs to ask is whether a particular digital asset is a security or not. The definition of a security under the Securities Act of 1933 includes dozens of items, but digital asset is not one of them. But there is something called an investment contract. And that term was largely intended to be sort of a catch-all term so that it would capture arrangements or products that Congress believes should be treated as investments and therefore regulated as securities. even though it wasn't one of the itemized products in the definition of a security. So the Howey test, which is the next bullet, refers to the 1946 Supreme Court decision that articulated what constitutes an investment contract. The Supreme Court held that an investment contract requires an investment of money in a common enterprise with profits to come solely from the efforts of others. Now, the specific facts of that case and what the Supreme Court was really trying to say when they articulated that test are issues that continue to be litigated today, that continue to be litigated against the SEC, including in some of the cases that we'll get to later. The next item here is the Dow report. The Dow report was issued by the SEC in June 2017. This arose out of an investigation. This report is called what we call a Section 21A report. It's what the SEC will issue when the agency believes that there may be some uncertainty or some lack of clarity in the securities laws and how they apply in a particular situation. So it's almost a tacit acknowledgement by the SEC that, well, this area may not be totally clear to the investing public, to the industry. But the flip side of that is that once the SEC does issue a 21A report, like they did with the Dow report, everyone is on notice of how the agency believes the securities laws apply in a particular situation. And that's why in almost every case that the SEC brings, in every complaint, the SEC will have allegations concerning the Dow report being issued in June 2017 and what it said. The main thing that it said is that the SEC was taking the position that the securities laws do apply to digital assets, and if they apply without regard to the form of the organization or the technology used to effectuate a particular offer or sale. The next bit of guidance that came out of the agency was in April of 2019, and this is shorthand referred to as the framework. This is not a Section 21A report, it's just staff guidance, so this is not an official statement from the Commission, but it is still viewed as very supposed to be helpful information for cryptocurrency companies, for cryptocurrency purchasers, as to how the SEC views these assets under the securities laws. What the SEC did in the framework is they basically took that Howey test and they asked, well, what factors, what characteristics of a particular digital asset will make it more likely or less likely to be an investment contract? And you would think that would be very helpful to people, but there were something like 30 or 35 different factors that the SEC identified that could make an asset more or less helpful. So I remember when this came out, talking to clients right then, the immediate reaction was, this does not help us at all. I can see why the agency would issue something like this. This gives them dozens of ways to say that a particular asset is a security, but for people in the industry, it just didn't really provide that much guidance. The next way in which the SEC believes they're providing guidance when it's actually not incredibly helpful has to do with no action letters. People can submit a request to the SEC for one of these letters, and when they do that, they will describe a particular situation or product or arrangement and ask the SEC, based on these facts, would the SEC be likely to conclude that there has been a violation of the securities laws? So a number of digital asset companies have done that. They have sent in these requests for no action letters. And at this point, I believe that perhaps 5 of them have been issued by the SEC. Again, you would think this would be very helpful that you have the SEC saying, we don't believe that there would be a violation of the securities laws here. However, the facts of each of these digital assets really is not that helpful. They're just very kind of specific to one ecosystem. They're not at all like the digital assets that you typically hear about as some of the more popular ones out there. So for much of the industry, this alone didn't provide that much guidance. The next item is really where the SEC has spent the vast majority of its resources. That is on investigations and enforcement actions. The SEC, at this point probably has dozens, if not well over 100, investigations going on. This will involve subpoenas, and eventually the SEC may decide to bring an enforcement action. And when they do, most of the time, that'll be in the form of a settled order. So it's just a settlement between the SEC and the party that they were investigating. Again, those often have kind of limited sort of guidance value for the rest of the industry because the SEC largely drafts what goes into these things. For people who are trying to play by the rules, it doesn't really give them a great sense of where those rules are. However, there are some cases that don't result in settlement. They do go to court. And when that happens, there's at least the hope that a court might do a better job of setting some of these parameters than the agency has. We'll talk about some examples of that later. We can go to the next slide. So the next question is, when and in what circumstances would a digital asset be considered a commodity under the U.S. commodities laws? Well, the definition of a commodity under the Commodity Exchange Act is really quite broad. So it's actually not that surprising or remarkable when a particular digital asset would be considered a commodity for purposes of those laws. The sort of clearest examples, least controversial examples of digital assets that are commodities would be Bitcoin and Ether. But we can imagine that there would be many other digital assets that should also be considered commodities. Sometimes the lines between these things are not always that clear, and both the SEC and the CFTC can make things confusing. One example that I mentioned before is BUSD. So the CFTC sued Binance in March of this year and alleged that BUSD is a commodity. When the SEC sued Binance months later, the SEC alleged that BUSD is a security. And sometimes it could be even more confusing than that. I mentioned state authorities earlier. The New York State Attorney General recently sued a digital asset company, and in the same complaint alleged that under New York state law, that Ether was both a security and a commodity. So for the industry, this is cause for no end of confusion. The Commodity Exchange Act provides the CFTC with regulatory authority as well as enforcement authority. One difference between the SEC and the CFTC is that with the CFTC, one doesn't need to register a commodities futures contract with the CFTC. You do have that responsibility with the SEC. You need to register the security with the SEC or qualify for an exemption. But with the CFTC, the issue usually is that if there's an entity that allegedly facilitates trading in futures contracts or other derivatives, that entity will need to register with the CFTC. And what's happened in some of the CFTC's cases is there will be an entity like that that took steps perhaps to try to not have contact with the US jurisdiction, but the CFTC alleged that those steps were wholly inadequate. They actually had lots of contact with US users and the US jurisdiction, and that's how they end up litigating with the CFTC. And as I mentioned earlier, when the CFTC, in addition to registration issues, the CFTC will also investigate whether a party has engaged in fraud or market manipulation concerning these types of contracts.
So what we have here is a an odd situation where, as Bill just described, the law that applies to digital assets in the US is in flux, but the penalties that apply to violations of those laws are very clear. So Elliot mentioned earlier that the types of violations that we might find in the crypto space, like fraud, insider trading, market manipulation, or failure to register, the consequences can be quite severe. Many potential violations can be pursued either criminally or civilly, but given the government's belief that there's extensive misconduct in the digital asset markets, a lot of which goes undetected, many violations, are, where possible, are going to be pursued criminally in order to promote the government's general deterrence objectives. The idea being, if there's a lot of misconduct out there and it's difficult to investigate and catch it all, when we do catch people, we have to pursue them as harshly as possible in order to send a message to other bad actors in this space. And so, of course, with criminal charges comes the potential for jail time. In the United States, in fraud cases and in white-collar cases generally, one of the most important factors in determining how severe the consequences are going to be is the amount of losses caused by the fraud or the misconduct. And we've already seen in some of the cases that Bill alluded to just how substantial the losses can be, which illustrates the potential for very severe sanctions in the event of violations. For pure regulatory violations, so when the DOJ is not involved, the main consequences are financial in nature, and that would include penalties and disgorgement of illicit profits with interest. Regulatory agencies can also bar or suspend individuals from participating in the industry. They can revoke licenses and do other things to make life exceedingly difficult for wrongdoers. Often in the US, criminal authorities and regulatory authorities will investigate in parallel and, if appropriate, bring enforcement actions and prosecutions in parallel. So defendants in the US might wind up dealing with both criminal and regulatory consequences for the same conduct. And then, of course, regardless of whether you face criminal consequences or regulatory consequences, there can be substantial collateral consequences to any violations or enforcement action. If we can move to the next slide. So most of the consequences that we highlighted in the prior slide have been trending significantly harsher in the US over the past few years. And one of the reasons for that is in the US, there's a political dimension to enforcement. The prevailing wisdom in the US is that white-collar enforcement tends to be more of an enforcement focus during Democratic administrations and somewhat de-emphasized when the Republicans are in control. My personal view is that the supposed differences are somewhat overstated, and that career prosecutors and regulators in the United States are going to pursue misconduct and violations wherever they see it. That said, over the past few years, if you just look at the data objectively, it does tend to suggest that we are in a period of heightened and aggressive enforcement. Just as one example, in 2022, the SEC broke several of its records regarding penalties, and 2023 looks to be a strong year as well. And within the context of aggressive enforcement generally, crypto is certainly a top enforcement priority. The SEC's digital asset unit has been incredibly busy, which Bill alluded to. There's been over 80 enforcement actions in this space, which is a lot, considering the time period in which crypto enforcement has been active. The cyber unit, the crypto unit, is well resourced and coordinates closely with its criminal counterparts at DOJ. I'll also note that when Gary Gensler, who's the current SEC chair, first took the reins at the SEC, he referred to crypto as the Wild West of the financial markets, and 80 plus enforcement actions later, that still seems to be the chair's view, and for that reason, we don't expect the pace of enforcement to slow at all in the coming years. So if we can move to the next slide. Before turning to cooperation between Korean and US authorities in the crypto space, we want to just talk very briefly about a few general considerations that apply to investigations by US authorities. The first point relates to what's called cooperation credit. Obviously, the best thing that anyone can do and the best thing we can do for our clients is to help them avoid violating the law. But if you have an issue or if your clients have an issue, there are substantial steps that one can take to mitigate the consequences of a violation. And we refer to those measures collectively as cooperation credit. So some of this you can do right now proactively if you know that you or your clients have exposure to US jurisdiction. A high quality compliance program is really important, not only because it can help prevent violations, but even in the event of a violation and determining whether to pursue it or how severe the consequences should be, US authorities will look to the quality of your compliance program and how it's evolved over time. Relatedly, US authorities place a lot of emphasis on self-reporting potential violations and also remediation as well. So these are all things that you want to be mindful of if you have exposure to US jurisdiction. You also have to consider how things like privileges and foreign data, privacy and bank secrecy laws might impact an investigation. Again, the US government places a real premium on getting as much information as possible. So one thing you need to think about is whether to waive any privileges and provide privileged information to US authorities and how to navigate any potential privacy and secrecy laws as well.
Cooperation between Korean and the U.S. authorities is slightly sort of a different topic, but to give an overview, there's a lot of cooperation between Korean authorities and overseas authorities, not just U.S., but like Europe and elsewhere, when there's an investigation, and there are many cases where like the Korean police or the prosecutors that conducted an investigation, not just in crypto, but whatever issue, where there's certain of the relevant information or persons were located overseas, and the Korean authorities sought legal assistance from the overseas counterpart under the Mutual Legal Assistance Treaty. But what we have seen, interestingly, is that in the crypto space, there's also a lot of unofficial cooperation going on, not necessarily under NLAT. To talk about NLAT first, some of the instances that we've seen, like NLAT requests being made by like the Korean police or the prosecutors, is it's like, for instance, when like sometimes when like multiple authorities and different jurisdictions investigate related matters, like I'm a little bit lost. When there's like an NLAT request made by, I think we should just go to the next slide. I think the next slide is more interesting. I want to talk about like some of the general ways in which the Korean authorities and the U.S. authorities cooperate with each other when they're simultaneously investigating a related matter, whether it's crypto investigation or whatever. It's not uncommon for like the Korean police or the prosecutors to request formal assistance to an authority like DOJ under MLAT. And one example that I've seen a lot is an MLAT request seeking personal information of a U.S. citizen who is a suspect in the investigation and who's not available to be investigating Korea. when a suspect is a foreign national residing outside of Korea, the Korean authorities often like to place a request with the Korean Immigration Office to alert the Korean authority when the suspect ever enters Korea. And then when the suspect enters, they would get notified, and then they would be able to investigate that person. But in order to place that kind of a request with the immigration authority, the Korean authorities need to have the personal information, like the full name and the passport number and things like that. Obviously, you would know the name of the suspect, but you might not have like other details like the passport number. And you may get that from the US DOJ under the and then place that request so you can investigate. And then sometimes the Korean authorities go a step further and would apply to the Korean court for an arrest warrant. Obviously, the arrest warrant that's issued by a Korean court would have effect only in Korea, but the Korean authorities might peg that and request Interpol to issue a red notice. And what we have seen sometimes is that like a US citizen that's located in the US has really no plans to come to Korea. So he doesn't really worry about the entry notice being in place with the Korean immigration authorities, but he might be traveling to other jurisdictions like Europe, where there's a risk of being arrested under the Interpol red notice and being extradited to Korea. So he might want to avoid that, and that's something that Korean authorities sometimes do. Next slide. Talking specifically about a cryptocurrency matter, where the Korean authorities and also the US authorities, DOJ is highly interested in the matter, and the SEC also investigated the matter. One thing that was very interesting, as I mentioned before, was the level of informal cooperation. Not just the formal cooperation under AMLAD, which is effective, but it could take a long time. But informal cooperation that we've seen in this particular case was that the Korean prosecutors that were investigating in Korea basically designated a prosecutor who is fairly fluent in English to communicate very frequently with the US authorities like DOJ and SEC to share information on the key facts and also legal theories. Like Bill and David mentioned, one key legal theory is this a security? Is this crypto really a security that needed to be registered? Obviously, the laws are different in the different jurisdictions, but there's some similarities because like the Korean law on whether something is a security, when the Korean law was established, they heavily took into account the Howey test in the US law, because US law at the time was more advanced. So it's not exactly the same, but it's similar in many ways. And so the US authorities' view on whether a given crypto that was offered both in Korea and in the US as a security could serve as a helpful guidance to the Korean prosecutors looking at the case and the Korean financial regulators looking at the case. So we've seen that they were exchanging information on like the facts and the legal theories and how to support the legal theory that something is a security. Although that would obviously ultimately be decided by the Korean courts under the Korean law. Going to the next slide. So there's a lot of cooperation that goes on when the two authorities investigate a similar or related matter, but at the same time, there's also some limits and challenges to cooperation. Like, for instance, some of the limits that we've seen are different facts may be important to each investigating authority, even if it's a similar matter. Or they might be interested in different people in a related matter, like the US authorities might be interested more in the US people, and the Korean authorities may be interested in the Korea-based people. And they would share information to the extent that's helpful to their respective investigation, but not necessarily everything. And then, but more importantly and more interestingly, there are some instances where the two authorities might be interested in the same person who is, and they compete to get that same person. Like for instance, if there's someone that is wanted by both the Korean authorities and the U.S. authorities, and both authorities want to investigate that person, but that person is actually abroad and neither in Korea nor in the U.S. What happened in a recent case that I've seen is that the Korean authorities and the U.S. authorities both placed a request with the Interpol to issue a red notice to get this person, and this person was caught in a third country, and both authorities are interested in getting this person to be extradited to their own jurisdiction for investigation. And whether to extradite when someone who is a suspect in two countries is arrested is decided by the country, the court of the country where that person is caught. So the third country, not the U.S., not Korea, but U.S. and Korea would both make an application for extradition, and various factors would be taken into account by that local court in the third country. The court in the third country might look at factors like which authority, was it the Korean prosecutors or US DOJ that placed the extradition request first? Who made the Interpol red notice request first, and who provided like more information, more detailed information? It's not just simply a matter of who put in the request first, like who actually put in like substantive request first, and different things that their country would look at. And then both authorities might contact that third country and try to get the third country to favor their jurisdiction in making the decision. And to some extent, the suspect's own interest in the own preference of one country over another might be taken into account by the court in their country. And then in a case like that, the suspect might consider like various factors, like what are the laws in the two jurisdictions? What is the law in Korea? What is the law in the US? What's the maximum penalty? What are the likely charges? What are the maximum penalty? And not just the maximum penalty, but what is the likely penalty, which is higher? And even like practical conditions, like if I go to jail in Korea versus if I go to jail in the US, which has nicer prison? I mean, very like practical considerations of the that a suspect might consider. Going to the next slide. So, it would not be surprising for the two authorities, like Korea or the US, to continue to cooperate to some extent, even after the investigation is concluded and the case goes, the case moves to trial. And we've seen, like in the Korean prosecutor case that is already with the indictment and trial is happening, we've seen that the information exchange is still continuing at the trial level. Like the Korean prosecutors and the SEC, and we understand from like the media reports that SEC in their own civil case is seeking testimony of individuals in Korea who might have information that's relevant to their case in the US. it's not clear how that request would play out, because there are multiple complications in actually affecting, actually getting information from defendants in Korea, but it's something that's interesting to see.
Back to you.
So just this year, we've seen some pretty significant developments in U.S. regulators' approach to crypto, and we can start. We're going to start with the SEC's enforcement actions against trading platforms. The very first enforcement action against the trading platform was Poloniex in August of 21. This resulted in Poloniex paying a $10 million total monetary relief. There actually was an enforcement action even before Poloniex, but that prior one was against a totally defunct trading platform, so the SEC actually discharged the individual in that case. But after Poloniex, there really wasn't another enforcement action against the trading platform until this year. And that's when the SEC decided to go after two pretty big ones with Binance and Coinbase. And of course, the difference between the Poloniex settled order and these active litigations against Binance and Coinbase is that Poloniex had left the U.S. market well before that settled order. So, Poloniex was just resolving issues with its legacy business. It was already operating outside the U.S. But for Binance and Coinbase, they are very much active in the U.S. market. They show no indication that they would stop operating there. So for them, these litigations are really existential because it's hard to see how they could settle with the SEC and continue to operate in the United States. Both complaints, there are differences in the allegations, but the charges are basically the same. SEC is saying that each of these platforms failed to register as a securities exchange, as a broker-dealer, and as a clearing agent. Now, both of these cases are still very much in their early stages. Defendants in both cases have now moved to dismiss the complaints. So there's briefing going on around that. But in the Binance litigation, actually much of the activity has focused around the SEC's early attempt to get a temporary restraining order against Binance US. This has to do with the SEC's concerns about what assets actually belong to Binance US, how much they are, and whether Binance.com, the global trading platform, the large company, has any control over the assets in the U.S. So they went to court seeking this temporary restraining order, and the judge in Washington, D.C. was actually rather skeptical of the SEC's arguments and allegations. She kept asking, point me to the evidence that shows that Binance.us has tried to move assets out of the U.S. or that they plan to move assets out of the U.S. Show me the evidence that .com could do that without the consent of the U.S. And the SEC basically couldn't point to anything. So the judge denied the application for a temporary restraining order. But the judge also recognized that these are important issues. So the parties, with the court's approval, entered into a consent order designed to expedite discovery into these very issues. And then the court will decide what, if any, injunctive relief she might want to impose. Just in the last few weeks, the SEC was back in court saying that Binance had violated that consent order. So they were arguing before the judge again, but again, the judge did not side with the SEC. She basically said, look, parties need to work out this expedited discovery, then an order, work it out, and if you can, come back to me. The Coinbase litigation, as I said, there's also been a motion to dismiss there. That is getting briefed. But these are still at a very early stage, and therefore it's hard to really see what could come out of them. It's probably going to be quite some time before we get anything, because there will be discovery probably months and months, if not years of discovery in each of these cases. However, even with some setbacks that the SEC has experienced this year, and we'll talk about a couple of those in a minute, just last month, the chief of the crypto assets and cyber unit in the enforcement division of the SEC gave a speech where he was warning that we will be bringing more enforcement actions against other trading platforms and intermediaries. So far the SEC does not seem deterred by any setbacks they might suffer in court. They're still pressing ahead. You go to the next slide. And while those other cases are at a rather early stage of litigation, the SEC's case against Ripple Labs, as well as 2 individual defendants, is much further along. As you may know, the central issue in this case is whether Ripple's token, XRP, is a security, and whether Ripple engaged in unregistered sales of that security over the last several years. The industry and the legal community has been observing this case very closely for the last few years. It's probably one of the most high-profile cases that the SEC has going on in trial now, going on in court. And the main reason is that, as I mentioned earlier, we've been waiting for the SEC to give more guidance around how the Howey test should apply to digital assets, but maybe this court will do so. And that is sort of what we got this summer. Both sides had filed motions for summary judgment in the case. So that means all discovery had ended, and each side believed that they were entitled to judgment as a matter of law based on the undisputed facts. Both sides briefed their motions, and the judge decided both sides' motions in late July. I think no one expected the judge to do what she actually did in this case. Her decision gave something to both sides, but this was largely a victory for Ripple. I should have mentioned, the 2 primary arguments by the defendants was that, first of all, XRP was not a security, it wasn't an investment contract, and secondly, that they had not received fair notice that their conduct violated the securities laws. This fair notice argument implicates the due process clause of the Constitution. When the judge decided summary judgment, she disposed of that second argument concerning fair notice rather quickly. She was not persuaded by that. So that was definitely a blow to the industry because many had been advancing that type of argument and continue to do so. But what was interesting was actually the first issue of whether XRP itself is an investment contract. What the judge decided is that for some transactions, in her view, XRP was a security, but for other transactions, it was not. And these were transactions that occurred at roughly the same point in time. But for institutional purchasers, sophisticated investors, she concluded that it was an investment contract for them because they had received disclosures from Ripple Labs, and they understood that the money that they were spending to buy XRP was going to Ripple Labs. So going back to the Howey test, under the court's reasoning, those purchasers had an expectation of profits from the efforts of Ripple Labs. However, for all of the other sales, the court concluded that it was not an investment contract. Specifically, for people who bought XRP on exchanges, including transactions where Ripple was the seller. So it was on the other side of the transaction. The buyers didn't know that. They just go to an exchange and buy XRP. Well, they had no idea that the money they were spending to buy XRP would actually go to Ripple Labs. And therefore, they had no expectation of profits from the efforts of Ripple. When this decision came out, the industry was very pleased with it, very excited. Over time, there's been sort of more thought given to the basis for this decision, and most importantly, whether it will hold up on appeal. The SEC tried to appeal this decision right away through something called interlocutory appeal. That's generally disfavored, but the SEC pressed for it anyway. But the court refused to do that. Instead, we have a trial coming up in April on the remaining claims that the court did not decide on summary judgment. And we'll have to wait until then for the SEC to appeal. And when they do, they will probably argue that the court simply got it wrong in treating different transactions differently for purposes of how. We can go to the next slide. So the question is, well, what is the aftermath of this, and what does all of this mean? I already mentioned the possibility of an appeal. We've already had one court say that it disagreed with how the court came out in Ripple. This is Judge Rakoff, the same court as Judge Torres, who handled the Ripple case. He expressly disagreed with the reasoning, and he's considered a highly influential district judge. So that is noteworthy. On the other hand, the SEC has suffered yet another setback that I mentioned earlier. It's not an enforcement case, but some of you may have heard about Grayscale trying to convert their Bitcoin trust into a spot Bitcoin ETF. The SEC has rejected that over time, and so Grayscale took them to court. And in doing that, the DC Circuit concluded that the SEC had acted in an arbitrary and capricious manner in rejecting Grayscale's application. It is highly unusual for any court to do that, and it's quite significant that that happened here. So that, again, brought a lot of enthusiasm in the industry that hopefully one of the spot Bitcoin ETF applications will be approved.
So we have just a few minutes left, so I'm going to talk very briefly about a few additional enforcement actions. So Bill mentioned enforcement actions against exchanges, and no discussion of that is complete without talking about FTX and SBF. I think everyone kind of knows the general story here. Crux of the allegations is that Bankman-Fried and others stole customer money through the use of a separate fund. Bankman-Fried is facing a whole slew of charges, both criminally as well as from both regulators in the space. Regulatory actions are stayed here, so we're not going to get to see the SEC and CFTC fight it out on the question of whether the assets are securities or commodities just yet. One thing that's really interesting here and very telling is how quickly the government moved to charge Bankman-Fried and others in the wake of the exchange's collapse. I think it shows the extent to which this is such a significant enforcement priority. As folks are probably aware, the Bankman-Fried criminal trial is going on now. The trial is estimated to last about 6 weeks. Bankman-Fried's defense is likely to focus on state of mind and an argument that he didn't have criminal intent because, quite frankly, he doesn't have any other defenses. And even that one is pretty questionable, particularly when Bankman-Fried and his co-conspirators talked about their illicit conduct in a group chat named Wire Fraud, which is not coincidentally one of the charges that he's facing. So we'll have to see how that plays out. Moving on to the next slide, please. Also have to discuss insider trading. The government in the U.S. recently had 2 significant victories here that will likely provide a roadmap for subsequent cases. The 2 cases are similar in that on the criminal side, DOJ pursued wire fraud charges rather than insider trading charges, even though the allegations sound very much like insider trading. Obviously, that's to sidestep this question as to whether the assets at issue constituted securities or commodities. Government got guilty pleas in the Wahi case. Both received sentences of imprisonment. In the Chastain case, the defendant was convicted after trial. That case is currently on appeal based on various arguments, one of which is that insider trading cases require the purchase of a security or commodity, and the NFTs at issue in that case, according to Chastain, don't constitute either, so there can be no insider trading. I think the takeaway from these cases is that when it comes to fraud in the crypto space or otherwise, U.S. authorities and other authorities have many tools in the toolkit, and they're not afraid to test novel theories in court, so it's important to stay far away from the line. Moving on to the next slide, while we're on the subject of NFTs, the SEC brought its first 2 enforcement actions against NFT creators. For a while, many commentators believed that the SEC might not have had NFTs in their crosshairs because they don't have some of the attributes that other assets in the digital asset space might have that might be more likely to render them securities. This doesn't necessarily mean that the SEC views all NFTs as securities, but it does suggest that there will be more scrutiny of NFTs moving forward, particularly where, as here, both of these sets of creators marketed the NFTs for investment purposes. Moving to slide 31, we spent a lot of time today talking about what the authorities have done, so I just want to talk for just a few seconds about what the authorities are likely to do next. Easiest prediction that I think all of us would make is that aggressive enforcement efforts are going to continue, in part for the reasons that Bill highlighted earlier about perception of bad actors and substantial illicit conduct. When Gary Gensler was floated as the new SEC chair, there was a belief that the SEC would start adopting rules to govern the crypto space. That is one thing that we can say is very unlikely to happen. We've also talked about what courts have been doing in this space, and we'll have to watch to see to what extent courts embrace the position of the U.S. authorities. So with that, I think we'll go to slide 32, and I don't know if Dan wants to make some concluding remarks.
Well, we had some interesting questions planned out and all that, just unfortunately we are out of time. So, I think this was a fantastic discussion about this new developing area of law. Like, Bill and David said, it's a Wild West, and it's interesting to see that this market is really leading the legislation and regulators development of policies and rules where the enforcement agencies typically follow once the rules are set and the laws are set, and the enforcement policies follow that. But now with this cryptocurrency industry enforcement actions, this is actually reversed. Feels like even a year ago there are questions about, is this really a security, or is it a commodity, or is it stable coin security, or is it algorithmic stable coin security? Scholars disagree, and a lot of different, even the former SECs and DOJ folks were skeptical about the SECs and DOJ's ability to enforce fraud action or go against certain actors, because they just thought that sometimes the investors risk that they will knew about, and we have rules to enforce such conduct. So now, in 2023 October, a lot has changed over the course of the year, and as Ed mentioned, the joint investigations and CAP investigations and MLAT is in full gear, and we've seen these types of operations and antitrust cases and some other corruption cases in the past, but it feels like that this cryptocurrency investigation actually draws more attention from various jurisdictions, and the types of operations that we see is I think unprecedented compared to what we've seen in the past. So. Very interesting discussion. Unfortunately, I don't think we'll have time for questions, but thank you very much, panel members, and thank you everyone for